SJC-13653, Margo Roman versus Board of Registration in Veterinary Medicine.
Okay, Attorney Coakley.
Morning, Chief Justice Budd, Associate Justices of the Court. May it please the Court, my name is Martha Coakley. With me is Kevin Chen, and we represent Dr. Margo Roman, a doctor of veterinary medicine in Hopkinton. We're here today because of a finding in error by the Disciplinary Board in Veterinary Medicine and the single justice that Dr. Roman was practicing beyond the scope of her license. We ask this court to find for Dr. Roman on this appeal and restore her license nunc pro tunc. I'd like to focus on three issues today. One, that Dr. Roman was not practicing veterinary or any medicine in sending her single email of March 16th, 2020. Second, this court decides, not the board, on the statutory construction of Mass General Laws, Chapter 112, both Section 58, which pertains to veterinary practice, as well as Section 61, Paragraph 1, that deals with the ways in which professionals can be disciplined. That applies to all disciplines like doctors, optometrists, chiropractors, etc.
In your first argument, so
Get the third point.
okay, go ahead.
So the third, quickly, is that we argue that given the board's decision itself, the length of time with two magistrates hearing, the argument before the single justice, and now where we are today, and the length and type of discipline imposed here, 2-year suspension of this senior, well-respected doctor's veterinary license, stripping her of her livelihood, her clients, and her ability to practice, the board has demonstrated, whether they intended to or not, their real intent to silence her for the content of a statement that she made within that email, portion of a single email that she sent.
Thank you. I'm sorry, Jessica.
So the first one, she sends out an email to all her clients. I'm just not sure I understand why that can't be practicing medicine. If she included in this email something outrageous, you should leave your dogs out in the cold all night long. It's good for them. Even though isn't that covered? I'm just confused why a general directive to all your clients isn't practicing veterinary medicine.
So it's a fair question, Your Honor, and one that I think everybody would struggle with until you immerse yourself into the statutes, as we did during this case, to take a look at what that statute, Section 58, defines as practicing. And this is important in the context of your question, which I'll get to in 1 second, but also in the context of the punishment imposed here under Section 61, Paragraph 1. So practice, as described in Section 58, is a series of things you do. It is diagnosing, making a prognosis, treating, administering, prescribing, operating on, etc., any animal or someone who cuts a tissue.
Directly or indirectly, and also treatment. I'm just, it's pretty broad.
And the directly and indirectly also comes into our argument, Your Honor, if I can digress for 1 minute, because the government argues that indirectly refers to almost anything. That's a limitless standard on what practicing would be. In other words, the context of this, and if you look at the regulations under regulations for doctors, for instance, and there's very little case law because I think it may be common sense construction, that the directly or indirectly refers to doing or allowing, supervising, overseeing any of those actions that follow. Otherwise, anything a doctor or a chiropractor or a veterinarian sending out or standing up and saying, I am a licensed vet, could be deemed to be practicing, but that's not the end of the argument. And I think to your question, Your Honor, the email itself is labeled a directive to prevent, to look forward. The title of the email specifically says, this is what we are going to do at our shop, knowing we are coming into a pandemic that we don't know anything about yet. We know a lot more now. And that email could have been sent by anybody. It could have been sent by a legal secretary. It could have been sent by someone in her staff. It is not practicing because it is not one of the actions the Section 58 prescribes, and they are specifically prescribed as things you do also in the context of a specific patient relationship. And I think all of those things are important to understand, that that's not practicing by sending out general health advice, even under her title, and that it's not practicing beyond the scope of her license, and those are two different things. If she is found to be practicing beyond the scope of her license, which is the single factor the board ended up determining, and that's where you look at Section 61, paragraph 1. It says, basically, that the board has relied on the language that says, if you are engaged in conduct which places into question the holder's competence to practice the professions. So there are instances where the board can find gross misconduct, fraudulent behavior, gross incompetence, negligence. The fifth item listed in that statute, however, is beyond the authorized scope of your license. That's what they're hanging their hat on this decision, that what she did, which we would argue is not practicing at all, because it doesn't come under that definition in the context of a relationship.
What's the scope of general health advice that's permissible?
What is the general scope?
As you see it.
So for a veterinarian particularly, they take an oath, and they are obligated by that oath to educate themselves and others in the interest of public safety, and particularly for veterinarians. But this practice is so unique, of course, because people live and work with animals. They intersect.
So if a veterinarian said reasonably, hey, all my, patients and customers or patrons, I think it's really important that we all eat healthy in today's times, that we shop on the perimeter of the supermarket and walk as often as we can and practice good health advice. Is that something a veterinarian could do?
I think that's right, Your Honor. I think they could, and in fact, they were encouraged, veterinarians were encouraged by the government to encourage others to get vaccines because they are at the intersection of health and animal personal health. Obviously, that intersects, as we know. Witness, the court can take notice of the bird flu concern, and we have, or with pandemic, obviously. And that's particularly important in this case, because educating herself and the public around these intersections and giving general health advice is all she did in that email.
Were she to say something that the government approved of, and the email said, there's going to be vaccinations coming out. I encourage all my patients to be vaccinated. That would be permissible.
I believe it would, under current status of where we are medically and what the government has said. And even more importantly, Your Honor, and it goes to this question, we believe there's a bit of a pretext going on here because the board did not like the ozone therapy.
That's the point I made. Had she given government-approved advice as opposed to this ozone therapy, we'd be in a different posture.
Well, correct. And if she had given advice like leave your dogs out all night, or we think heroin is a good solution for the pandemic, she could be found by the board under many of these conditions to be demonstrating competence that shows she shouldn't have a license. But that's not what they said. They went down that road, in fact, in front of the single justice.
So your view, it's the message, not the messenger, that's the issue here.
I'm sorry, Your Honor.
It's the message, not the messenger, that was the issue here.
I think it's a little bit of both, exactly. And they are saying that you, as a doctor, and the single justice kind of found that because she was holding herself out, she could be practicing. And if she had said something that indicated negligence or incompetence to practice, that would have been fine. And the cases that we've looked at, and there aren't many, the board has great discretion, as it should, to protect the public. Very few cases get decided or come before you on this. But this one is different, I think, because the message involved, and we didn't argue First Amendment, obviously, in our brief, but it does impact now if this court finds, which I believe it can, that there was no practicing.
But she's prescribing I don't know what this is. The ozone, how does it work? Is it an apparatus? I don't know what it
It's
is.
an apparatus, but there's no prescription involved. She recommends, and she says in the email, this is good for people and animals.
I understand. So, again, that gets back to, is she directly or directly prescribing something which she seems to be doing for both animals and people, right? She's prescribing this ozone. Isn't she telling them?
She's
go
recommending
and
generally
improve more?
something, but there's no
But isn't she-
prescription to a particular person to
Well, but
take
she's telling
this.
all her clients to do this. And furthermore, she's saying, and this is, she's saying, tell them I told you to do this. Is that so that she has some kind of financial or relationship? Or no?
No.
I mean, so why is she telling them, tell them I sent you?
She says specifically in the email, Your Honor, that if you are interested in this, tell them that we sent you because they know that we, Dr. Roman at MASH, are interested and knowledge about this, and they will help educate you on how to use it. Those are all for sale, by the way. You can get them on
That's
Amazon.
not practicing veterinary medicine.
I would argue it isn't, Your Honor, and I do think you have to go in to look at those statutes, the case law, every single case that deals with discipline of someone under these circumstances is in the context of a patient-client relationship,
but-
not general
so
advice.
If we disagree with you on that, though, that prescribing this, we consider this practicing medicine in some respect, do you lose?
No, because I think, and I'd like to argue today, I realize my time is running short already, that even if you were to find it practicing, which I think when you look at the statutes you will not, you can find that this portion of one email sent in general to people on the eve of pandemic is not indication that she is practicing incompetently beyond her license. That's what the board below failed to do by any kind of evidence to show that this one thing says, we need to shut this doctor down for 2 years. We're gonna strip her and her patients, her clients, of her services for 2 years. It's excessive, it's punitive.
Even with the findings that they made about the toxicity of this therapy?
Well, fair enough, Your Honor. Before the single justice, they argued, the government, that this is toxic and we have all these announcements that it's toxic. But interestingly, what they included in the record was published after she sent that email, not before, and they have backed off that argument. The government now says, we are not arguing about the merits of the ozone therapy. In fact, if you look at the CMR, the regulations for veterinarians, they talk about what are some of the alternative holistic ways that this is proceeding. And they have both, they mention ozone therapy in the CMR, Massachusetts CMR, and they have standards that says the one thing we think you need to do if you're going to use this is make sure the client you're talking with about these therapies understands that they may not be considered conventional medication, but they are on the cutting edge. That's exactly what the amicus brief talks about, filed with this court, that this is cutting-edge research, it's important, it's regulated, and the board backed off saying, we think ozone therapy is dangerous. We're not talking about that. We just think she practiced beyond. So I think there's several reasons that this court can find in this limited case, the board overstepped its bound, however well-intentioned it was, and sanctioned and punished this doctor in a way that was excessive, out of line. Not that there are a lot of cases on it, but often people get 18-month suspension. That stayed, which it wasn't in this case. She has not been practicing for this period of time. It's a huge hardship. This decision was wrong. This court can remedy that, and I would ask that the court fine for Dr. Roman and restore her license no pro tonque.
Okay, thank you.
Thank you.
Attorney Golke.
Good morning, Your Honors. May it please the Court, Grace Golke, Assistant Attorney General, appearing on behalf of the Board of Registration. We're asking this court to affirm the single justice and dismiss the petition. The board here acted within its statutory authority and its substantial discretion in sanctioning Dr. Roman for practicing her profession beyond the scope of her license. The March 16th, 2020 email was a targeted communication sent from the clinic's email to her client list to facilitate her treatment and care of her animal patients. And Dr. Roman held herself out in that communication as someone who, and she was indeed at the time, qualified to practice veterinary medicine. However, while practicing within that scope, or it started out practicing within the scope, but then the suggestions that she made in the second portion of the email went beyond the scope of her license by advising humans on how to protect their own health.
Okay, but that's where I want to try to figure out. So obviously, we're in the pandemic. The humans are taking care of the dogs. The humans are also somewhat interacting with the veterinarians. So she's got to be able to say certain things, right? I don't know if she's gone too far here, but can't she say, you know, take really good care of yourself, abide by the governor's restrictions, and stay away from people? Can't she do that? I mean, if she wrote something that just tracked what the governor was telling people to do, wouldn't that be okay?
Your Honor, I agree as a starting premise. There are things she can say, including the things she says in the first portion of the email.
I'm focusing on what she says about humans. And doesn't she have some ability, because the humans, we also, at this point, I don't know, do we know that COVID and there's no human animal transmission issues even? It's early in the game. We're all frightened. I'm just trying to understand what she's got to be able to say some things. Now, she may have gone too far and prescribe ozone treatment, you know, and tell people she wants them to contact their people and tell them, but that may be different. But she's got to be able to give some advice about taking care of yourself, because there's some interrelationship between your own health and the dog's health.
And Your Honor, I think she can speak to issues that are related to her practice. So things that, for example, she has pointed in the briefing to the fact that the hearing officer excluded a portion of the email from the practicing outside the scope about ozone as a disinfectant because of pet hair being a surface on which the COVID vaccine, or excuse me, the COVID virus could live. So the board was very careful in distinguishing which parts of this email are related.
But my understanding, again, I may be oversimplifying it. They're saying everything she said about the animals is fine. Everything she said about the people is no good because she can't give any medical advice to people.
So I wouldn't say it's anything she says about people. It's things she's saying about humans that are also unrelated to the scope of her license. So if, for example, she said something, and it wouldn't make sense at this point in time.
Take good care of yourself.
I think take good care of yourself would be so generic that, that there would be no problem.
How about abide by the governor's restrictions on staying away from other people? Your health is important to your dog's health. I worry that.
I think if there were that link, if it was taking care of yourself is important to your dog's health, and here's...
She says a little of that, doesn't she?
Well, what she says is that ozone is effective for both humans and animals, so that's as two separate... It will help your animals. That's, I think, within the scope of her license. Also, it will help humans. That is outside the scope of her license. It's not about the link between the two.
That's where she goes wrong, when she gives any kind of... I'm just trying to get us... Because the next case, you know, I just want to make sure I understand what the holding of the board is, which is, where did she go too far? If it's limited to prescribing this novel treatment to humans when she has some kind of championing of it out there in public, I understand that may be one rule, but if it's no vet can give advice to their clients about preserving their health, then I'm nervous that you've gone too far.
Well, Your Honor, I think there's a number of guardrails on this, which is, one, she has to be practicing in that moment. So a conversation that she's just having with someone where she's not in that moment practicing her profession, that wouldn't be covered by this.
Her website says, you know, I'm a believer in this one philosophy. Your health and your dog's health are interrelated. take good care of yourself, here's some good techniques, eat lots of vegetables, and she's going to be disbarred, or whatever the equivalent is for, as a veterinarian?
Well, Your Honor, the board did distinguish this communication from something like a general website. That's in their response to, I believe, objection 4 within their final decision. So what they were especially concerned with here is that this is a targeted communication that people are receiving because they are her clients. They don't just happen to be her clients. They're receiving it in their capacity as her veterinary
If
clients.
you look at a website, you're doing it because you're interested in having them be your vet, right?
Well, I think the concern here is that these are people who have acquired her services for a specific purpose, which is to be a veterinarian, and that they trust her for that purpose. And they don't necessarily know exactly what the limits of that license are. It's the board, it's the professionals that monitor the differentiation between various licensed professionals.
They don't, I mean, like, I take my dog in because the dog's paw hurts. I don't ask the vet to fix my hand because I've got, stiff knuckles, right? I mean,
Right, Your Honor, and I think for the same reason that on the other side of that equation, the veterinarian has an obligation to also limit themselves to what is within the scope of their license.
So if parts of her email were permissible, and there was a smaller part that was impermissible that strayed, and it's in the beginning of the pandemic when everybody doesn't know what's going on and people are panicking. So the intent is something we can think about. How does that get you a harsh 2-year termination?
Well, Your Honor, the sanction, which there's particular deference given to the board's assessment, and it was looking also at aggravating circumstances involved in the prior disciplinary matters. So there had been, I believe, 5 prior disciplinary matters that were progressive. So it went from a $100 fine to ultimately, I believe, a $1,000 fine and probation. And so it is perfectly appropriate for the board to tailor the newest sanction in light of that.
What were the other sanctions for? Were they similar to this type of thing?
No, Your Honor, they were separate. There was some about medication, securing medication properly. There was some about administering care under the standards of care. But the board's regulations its provisions that provide for progressive discipline don't say it has to be, it's only under the same subsection.
No, I mean, I understand that it doesn't have to be, but when you look at the totality of the circumstances, I would think that.
Did they take into consideration mitigation in this case?
They did, Your Honor. If you look at the board's decision at the very end, so there's the part of the board's decision that's responses to objections, and then after that, you'll see both mitigating and aggravating circumstances. They acknowledged that there was no evidence of bad intent here. They acknowledged that there was no evidence that someone had followed this advice. So there was recognition of those mitigating circumstances in addition to the aggravating ones.
Did they take into account the state of knowledge about the pandemic at this point?
I don't believe they made an explicit finding about that. I would say that the state of knowledge sort of cuts both ways here. I think that makes it even more important in times of uncertainty that professionals do remain squarely within the scope of their own licenses and don't start, giving advice that could relate to another licensed professional.
The thing that's striking to me, it seems that this is content based in that had she said, wear a mask and socially distance, the government would be A-okay with that. But because she said this alternative type of treatment, then she's in violation.
Your Honor, I disagree. I don't think that the board relied on the specific content. They were very clear repeatedly in saying this is not about whether ozone is or is not a good and effective therapy. Where I think it...
isn't that a problem, though? Because I have the same concern Justice Gaziano has, but maybe from a different angle, which is, don't you need this treatment to be out of bounds for this to be a disciplinary offense? And if it's just generic wear a mask, she shouldn't be disciplined at all.
Well,
Don't we really have to find that this is kind of a kooky treatment or for us to justify this?
So I think that there are several different decision points here. And what we're talking about is the liability. That's what's being challenged is, did she violate the statute by practicing outside the scope of her license? That liability finding is not dependent on the content. Where I think you could see the discretion of the board is both in the prosecutorial discretion of, is this a case that they're going to pursue? Is this a case they even received a complaint about? In this case, they did receive a complaint in something perhaps totally and utterly innocuous. No one would bring that to the board's attention. And then on the other side is the sanction. So the board can consider, based on the particular circumstances, what sanction is appropriate. And that's a strongly discretionary decision where the board weighs those mitigating and aggravating circumstances. So there are, although the liability finding does not depend on what the out-of-scope communication or the out-of-scope conduct was.
But I'm sorry, go ahead. I'm still struggling with this because part of what we have to do with these decisions is to give some clarity to folks out there about what you can and can't do. And, Justice Gaziano started this with the content-based component to this. If you're saying that it hadn't anything to do with the content and that she just can't give, or any vet can't give human advice independently, what are we telling the vets to say? That if somebody happens to have some interconnection between what's good for their animal and what's good for the humans, that there's supposed to be all of these disclaimers that whatever I'm telling you is only for purposes of your animal, and I can't mention whether eating healthy or taking walks or wearing masks or socially distancing. I can't speak to any of that because that would subject you to the board contending you're practicing outside of your license. What message is that going to, how are we going to educate the folks out there about what they can and can't do?
Well, Your Honor, there does have to be a line here in what is within the scope of veterinary practice as opposed to any other licensed professional. And so I do think the board is the body best placed to decide where those lines are. They are themselves comprised of 4 veterinarians as well as 1 member of the public. This is, they are experts on where is that line in the in conduct or in communications that are at that intersection of animal and human health and do fall within the scope, and then the communications and conduct that are outside the scope.
Can I ask a follow-up on what Attorney Coakley says? I'm bothered by the buy the ozone and tell them I sent you. Should that be not a consideration for this court? Because if you agree it shouldn't be, I'm not going to worry about it. Or is that problematic because there may be some kind of prescribing of something to humans in which this person has some kind of proprietary or other interest in it?
So the board did discuss that referral link. It's in their response to objection 13. And the way that they considered it was that it supported the conclusion that this was practicing because it was a targeted communication that was intending to direct specific advice to her client base. So that's where they incorporated that factual element. So I wouldn't say the content is irrelevant. What I'm saying is just the...
Again, trying to define a rule that we can enforce. Is prescribing something to humans in which you have some kind of particularized interest, does that cross the line? Or is that what makes this different from saying wearing a mask like the governor said?
Your Honor, I don't think I would define the rule so narrowly. It did also find that the other 2 paragraphs about homeopathic medicines and...
But again, she's a champion of homeopathic medicine and she's using that in her email to her clients. Is that, again, some way that we can distinguish this from, take good care of yourself, follow the governor's directions,
Well, Your Honor, I think the issue is, and this is in the board's response to objection 17, the problem here is she failed to maintain the boundary between her veterinary practice and other knowledge she might have. And it is very important to all boards of registration for the public health and for the integrity of the professions that licensed professionals are diligent about what are the boundaries of my license, when am I acting in that capacity, and how can I ensure that I stay within the bounds of that license. So I do think the issue here is that when acting in the capacity as a licensed veterinarian, there is an obligation to maintain that boundary between that specialty, that licensed profession, and then other areas of knowledge someone might have and can share in other contexts absolutely freely. If the court has no further questions, we would ask you to affirm, and thank you very much.